The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, you're not getting an invoice. I'm Simon Jenga, and welcome to Simon Says. Today we are talking about revoking and updating your existing will. And there's a number of ways that you can change your will. So we're going to roll through them one at a time and cover off the key elements of how and why. But before we crack into that, the most important part of changing a will is still having the legal capacity to sign a will at the point when you try and vary it. Now, lawyers will make determinations of capacity based on medical advice and how the client presents at a meeting. So when a client is changing or updating their will, it's important that we're reviewing the client's capacity, whether you understand the consequences of the change or revocation that you're intending to make, and that we have clear instructions of what you are going to do next. It's never really an ideal situation when someone wants to revoke an existing will without putting a new one in place. It's much more common that we would get changes done to a will where if an old one is being removed, then it's being replaced with a new one, or that an existing will is simply being adjusted, tweaked, changed in some way to then be still their will moving forward. So making sure that we have clear instructions and that you have the capacity to make the decision to update your will, vitally important as part of the process. And it's something that we can only do with you, the will maker. So we can't have a family member answering the questions for you. We can't have a little decision committee telling us what you want. It has to be coming from you, and it has to be clearly coming from your mind. Now, in terms of the ways that we're going to change a will, the first is by choice. So let's call it voluntary variations to a will. And this could be to outright revoke the will. And you can do that by destroying the will with the intention of revoking it, or striking it out, ripping it up, burning it, all classics in terms of getting rid of a will. But it can be as simple as sending an email through to your lawyer saying that I revoke my will, or a phone conversation that is then file noted by the lawyer that the will is revoked. So that process of revocation is really about notice, that whoever is holding the original copy of the will knows that it has been revoked and therefore can act accordingly moving forward. If the will is going to be varied or changed and you're choosing to do it, then it's simply a case of drafting either a codicil or a new will. Now, I can hear you screaming, what is a codicil? Okay, so a codicil is simply a variation to a will. That's all it is. It's a fancy word to describe a variation. But, importantly, the original will still remains in place. The codicil or variation document is now in addition to the original will, and those two documents together now form your will. As opposed to having a will and then deciding to change it, revoking that will, and preparing and signing a brand new will. In the good old days, codicils were very common. In more modern times, we tend to just revoke the prior will and sign a completely fresh new will. There's a few reasons for that. One is the ease and low cost of just doing a new will rather than doing a variation, because effectively the cost of drafting the document is exactly the same. And the reason that's important is because if you have a codicil, you now have two documents that you need to keep safe, make sure they're valid, and then when you do pass away, we have to deal with explaining to the court the process of variation. If we simply revoke the prior will, execute a new one, it's much cleaner and much more straightforward. So my general recommendation would be just to do a brand spanking new will. The added benefit is that we get to do it on modern terms using the best possible wording that we currently use, as opposed to whatever was in your last will, which, if it was done by your existing lawyer, was almost certainly their best of the day. But if you signed it in 2007, a lot has happened in the interim. So a document executed today is going to get the advantage of all that increased knowledge of your lawyer to then be able to do an even better version of your will now. And that really sums up how you can voluntarily change or revoke your will. But that's not the end of the conversation, because there are ways that your will can be revoked involuntarily, either fully or in part. Now, in full, a will is revoked at the point when you marry, if you executed the will earlier. So, I am in a relationship with someone, or let's say I'm single, and then I execute a will. I then get together with someone, we get married. As soon as I marry this person, then my prior will is now void. It's of no effect. It's not worth looking at. The courts won't consider it. It's not informative as to what my wishes could have been. That's it. It's void. And I'd have to do a new will after I'm married. The only way around this rule is if you execute a will in what's called contemplation of marriage. Two critical points. It doesn't have to be in the will, but it definitely helps from an interpretation and demonstrating to the court perspective if that wording is in the will. And secondly, you have to be in contemplation of marriage to a specific person. So, in my example where I'm single, I can't be in contemplation of marriage to anyone. If I was in a relationship in contemplation of marriage to Sarah or Natalie, as my wife is, then I would be able to have the will survive if I married that person. So that's critical to that process. And if you are in a position where you've recently got married and you had a prior will, then it's well worth checking whether that will is still valid or whether it has been revoked automatically. Now, wills can also be revoked in part, and ironically, that happens at the back end of relationships. So on divorce, and I'm going to return to why I said divorce and not separation, but on formal divorce that is signed off by the court, then any reference to your ex-spouse is now removed from the will, and it is deemed that they passed away immediately prior to you when interpreting your will. So if, for example, your will said, I appoint my spouse as executor, and failing that, my eldest child, now the will would simply be that the eldest child is automatically appointed as executor, and it doesn't go to the ex-spouse. So that means that the will is still valid, it still exists, but any reference to your ex-spouse is now deemed to be struck out. Now, the reason that I said divorced rather than separated is because your ex-partner is not removed from your will if you have simply separated. It only occurs after divorce. So if you've been separated from your partner even for 10 years, but you never formally got divorced, then if they are still in your will, that is still valid. So again, very important to check when you separate, rather if you separate, that you change or update your will to reflect your new wishes. So today, Simon says, as long as you have mental capacity to understand the consequences of your actions, there are a number of ways that you can revoke, vary, or update your will. For more legal insights, check out our other episodes, subscribe to our channel, and remember, at LOA Law, we are good lawyers for good people.